could please have your attention.
Congratulations. It's been really, yeah, pretty amazing.
As you all enjoyed today's fellowship and we celebrated our beloved hike, one theme that kept coming up is how much hike has done for St. Gregory. And whether that means physically coming and supporting or financially supporting, Hike has been at the helm and has been an example for all of us. However, sometimes we might not know how to be supportive, especially when it comes to the financial aspect, whether it is donating, stewardship, membership, or other ways. And so, on this day, we're also blessed to have within our parish, attorney Rudy Minasian, who doesn't really need an introduction. You all know who he is. And Rudy's expertise, specialty is, in fact, answering some of those questions regarding finances. And so I'm going to invite Rudy up, who's going to be doing a special presentation today with St. Gregory and AGBU in conjunction, together working, tackling and discussing this very topic. And I know he's going to do it, as you can see, there's no screen behind me, because he said he wants this to be interactive. So everybody clear your voice. You're all going to be participating in this presentation. And so we welcome Rudy for this wonderful occasion.
Thank you. See, we've kind of waited until the room cleared out before I started. Good choice. Husband and wife come into my office a few years ago and talked about planning and what to do and what happens when one or the other passes away, and they decide that the husband most likely will pass away first. And so I'm explaining the trust, and I'm telling them once the first spouse passes away, we can make it such that the trust is locked in, where nothing can be changed after the death of the first spouse. And the husband looks at me and says, yeah, that's what I want, because I don't want her giving my money to some jerk after. And the wife looks over and says, what makes you think I give the money to another jerk? So that's kind of the attitude people have coming into my office. But I want to generally touch on, and as this is going on, feel free to interject, raise your hand, ask questions, throw me off as best you can. But wanted to do, as best I can, explain to you kind of the what, when, where, why, and how of planning, especially in today's climate. I hope we're not all living in fear, but the honest truth of it is you never know what's going to happen and when. So the best thing you can do for yourself, for your kids, if you have kids, for your spouse, for nieces, nephews, is have a plan. Have a plan in place. And I'm doing this probably 40-50% of my workload is estate planning. The other half is a mix between a lot of different things. But I've been practicing 20 years, and of all the things that I've done, probably the most needed service is the estate plan, without question. Because and the word death and dying obviously is everybody kind of has a different interpretation of it. Very touchy subject for a lot of people, but we're all going, one way or another. We are all going, and the sooner you come to grips with that, the sooner you're able to just clear, I guess, the emotional aspect of it. And all our divine sparks do fizzle out at some point. You can make a plan to help your children, to help your family after the fact. So the first thing I want to touch on is really the difference between, or what a will does and what a trust does. And a will is nothing more than a set of instructions for someone to follow when you pass away. That's it. You say who you are, generally where you live, who the person is that's in charge after you pass away, and what you want to happen to whatever stuff you have at that time, which we call assets. Legal term is asset. So that's what a will is. There are limitations to a will. It's decent way to have something in place. Okay? How many of you have heard the phrase trust fund baby? You're familiar with the phrase trust fund baby. How many of you think trusts are only for trust fund babies, or only for people that have lots of money? So, and I hear a no right there. So trusts are just a different estate planning mechanism than a will is. Really, it has nothing to do with how much money you have. It has more to do with whether or not you have a plan in place going forward. So, in comparison to a will, which really doesn't take effect until, and a will is not a will until a judge says it's a will. So, when someone passes away, you've got this document, and it purports to be a will, and the rules of executing it are set forth in the law, and every state's a little different, and there's got to be witnesses, and there's got to be a notary, and then when someone passes away, it has to get filed with the county. A trust is separate. A trust is almost in comparison to a business entity. It's this separate existence. And it is, unlike a will, it takes effect while you're living. And it's this, I always explain it as this shell or this refrigerator. So bear with me for a moment. If you picture a refrigerator, you go to the store, you buy a refrigerator. It's this empty shell, okay? You plug it in, it turns on, it cools whatever's inside. It serves no purpose until you put assets into it. So you put fruits and vegetables into it. Trust is the same thing. When you shift those assets into a trust, now they're protected by that shield, if you will, by that shell of this trust, this mechanism. And in doing that, there's a slew of aspects to this, but the one that we're all, I think, getting barraged with by the media lately is government controls. In not doing anything, okay, so you pass away tomorrow, you didn't do anything. Everything has to go through the court system, through this process, this probate process, before it can be disseminated or distributed to kids or whoever it is that you wanted it to be distributed to, if you get that far. Sorry, I lost my train of thought, but the point is to get it out of the hands of the court system, okay? Because it's, again, that's what I was getting at, was there's more, it's just more government oversight. So, you don't have a trust, you don't have a will, you don't have anything in place, you have a house, you have some savings, you have mutual fund, you have retirement, whatever the case may be. If there's no plan in place, you are saying, okay, Cook County court system, government officials, a lot of them are elected, but there's not enough judges to go around, so a lot of judges end up getting appointed as kind of sub-judges. You've got appointed people, government officials, that decide what happens with your money. They decide what happens with your house, they decide what happens with your bank accounts, they decide what happens to your children, they decide who you have to pay and when to distribute all of this stuff. So by doing nothing, which is an option, doing nothing is a choice, that's what you're left with. And many people are okay with that, and that's fine. My goal is to kind of give you, in a medical term, informed consent, so that you know what you're walking into, and if you decide, I don't want to do anything, fine, so be it. I'm not judging, everybody's free to do their own thing. Just know what effect it has down the road, what burden you're putting on children or whomever it is. So, having a will or doing nothing, either way, it has to go through the court system. It has to go through a judge. They're going to make decisions for you on your behalf, on the law actually controls it all, but on behalf of the executor or administrator of your state. On the flip side, by putting it into a trust, you are now shielding it, in a sense, from the court. Whatever assets there are, when you put those assets into the trust, probate court no longer has any say in how any of this works, okay? Until and unless there's a contest. Somebody feels like they were slighted, and I heard my aunt was going to leave me $500,000, and her trust or her will didn't say that, and I feel that somebody kind of deceived her. Then I want to challenge that, so be it. That would end up in court, but that's a whole different story. So, what we're getting at here is will-based planning versus trust-based planning. When you have a will, you still have to go through the system before your assets can get disseminated. When you have a trust, as long as you fund it properly, it's all in that refrigerator, which has a lock and key, and when you pass away, the keys get passed on to whoever you put in charge. They go and they unlock that refrigerator, open the door, and they distribute the assets to whoever is supposed to get them. So the concept really is that simple. Putting it into play is another story. It's not that simple to effectuate, but the concept itself of keeping everything out of court, and there's multiple reasons to do that. One reason is, and when I talk to my clients, I kind of gauge, I gauge their interest, honestly. I'm looking to see, are they more money driven? Are they more financially concerned? Are they more concerned about, on my end, are they more concerned about getting good service? Are they more concerned about welfare of their children? Is there some other thing, like special needs, that comes into play? So I'm thinking about all these things when I'm doing the planning, and whether it's me or whoever it is, a good estate planner is going to sit down face to face with you and talk to you. They're going to get a feel for your family. They're going to get a feel for your situation. They're going to get a feel for your health. There's so many different things that you have to, as the planner, financial planner, same thing, know and understand before you can actually implement an effective plan for someone. Family dynamics. Obviously, family dynamics comes into play huge, but going back to what I was saying, putting it into that trust, putting it into that shell, into that shield, avoids the need for court. Okay? You're calling the shots, frankly, from the grave. You're calling the shots from the top. But you made all those decisions beforehand. You've stopped the potential for in-family fighting, which is another big thing, obviously. And I say obvious with regard to, if you see the ones that are on the news are the famous people. If you look at the Aretha Franklins of the world and the Princes of the world, I know they had tons and tons of money. They had Aretha Franklin, supposedly her will, there were multiple wills, and one was between couch pillows. I remember reading Prince, he had cousins coming out of the woodwork, probably still to this day, 5+ years after he's passed away. So when you have that trust in place, you're avoiding the potential for all these problems down the road. And I can go into plenty of nightmare scenarios. If you went to, I remember one time I had gone to a court clerk and I was talking to the judge's clerk, and I asked about contests, will contests versus trust contests. So when you contest a will, you are saying whoever person is that drafted that will, they either had a gun to their head, they weren't in their right mind when they did their will, and whatever they set for their distributions is incorrect. You're challenging. A third of will challenges are approved. The court will overturn it, will toss the will. 1/3 in Cook County. With trust, and you'll see plenty of will challenges, tens of thousands possibly a year. Not about that, in Cook County. Trusts, way harder to challenge. The reason is, and then with trust challenges, you might see 1 to 2 a year, whereas will challenges, you'll see thousands. Trusts of the 1 to 2 a year that get contested, it's rare that they're successful. Over multiple years, you might have one successful contest. I don't want to get too much into the court stuff, but it gets more into the battle. If you drag out the battle, if you're somebody that's contesting and you drag out the battle long enough, then you're going to compel the other side to just settle and resolve and not get to a resolution. Yes, Gary.
So apart from will contests, are there sort of common ways that people don't expect that the probate court might do something different than what the will says?
No. So Gary's question was, apart from will contests, is there something that the court might do to what we would call a constructive interpretation, or some other interpretation than what I guess the parties think the will says? That's rare. The judge's goal is to basically make sure that the testator's wishes are confirmed, are implemented through whatever process, through the probate process. And so if there's a gap in the will, such as, a simple one would be the will doesn't say what happens to the vacation home. Okay? At that point, it's up to the executor to decide. Does the executor turn the vacation home into rental property, pass along the income to the beneficiaries. If the executors sell the vacation home, gather the income, pass that along to the beneficiaries. Are there assets that are longer term? Let's say you own, I'm going to use, a lot of people know me through like baseball stuff, but if you own a baseball team, okay, usually there's dozens of owners, maybe 50, 60 owners. None of them have any control except the one that's appointed the boss. If one person passes away that's in an ownership group, whether it's a baseball team or any kind of small business, usually they have no say in what happens with their shares. The company may offer to buy the shares back at a discount, most likely. But when that person passes away, the kids can't just go sell their interest. And that goes for any small business. If I and my brothers have a trucking logistics company, for lack of a better term, and one of us passes away, the company's documents are going to control or say what would happen with the ownership interest. So getting back to Gary's question, if there is a gap or there is an asset or whatever the case is where potentially it's not clear or it's locked up, you just can't do anything, one or two things will happen. The judge is going to ask for some sort of hearing and evidence as to what the goal was, what the testator's desires were. Or the judge is going to make, there's going to be a hearing, the judge is going to make a ruling. Okay, one way or another, they're going to decide. They don't want these cases on their docket. I remember one time years ago I went into court, they were shuffled, all the judges, at least in Cook County, all the judges that deal in probate are on the 18th floor. There's 8 of them maybe. At one point there was one single judge dealing with all of the decedents' estates in Cook County. They had 18,000 cases on their docket. Okay? So the moral of that story is the court doesn't want to deal with these cases any more than we want to have to go to court on these kinds of cases. One major reason for estate planning is probate, on average in Cook County, takes 2 to 3 years from beginning to end, on average. With the market had crashed in 2008, there were cases they couldn't sell the real estate, people couldn't sell the real estate. Probate matter just stayed open perpetually. It went on years and years. And the judge would make the attorney come back every 3-4 months before, just for a status update. So I'm the attorney, I'm building my client to go downtown, paying $60 to park, aside from all the other related costs, to tell the judge nothing. There's been no updates, we can't sell the real estate, we're frozen. And they make you come back over and over because the court system wants to make sure the attorneys are working the cases, and the judges try to stay out of the cases as much as they can, at least in this type of case. Because it's just overload, there's too much on the docket, they can't deal with it all. If there's a dispute that needs to be resolved, they'll have a hearing, they'll call you in the chambers in their office, and they'll try to work it out there. So I know I'm getting into the more of the court stuff. This is what we want to avoid. Okay, and this is what a trust does. It's the reason, there's a couple reasons for it. A will follows the law of wills. Every state has its own law regarding wills. A will has to be probated, an inventory has to be filed so the whole public knows all your assets. I gotta file something with the court that says what the value of the house is, I gotta get an appraisal, the value of your assets are, the value of any investments, retirement accounts that were in your estate. And the court needs to know that, and when the court needs to know that, the entire public gets to see that, because those are all public records. The will is public record. All the filings are public record unless they're under seal for some reason. The law of trusts is, in a sense, the opposite. A trust is a contract. It's just a private contract. So I have a contract with someone, nobody gets to see that contract, except the parties to the contract and anybody else that needs to see it because they're involved in it one way or another. When you execute a trust, it's a document the way a will is or the way any other contract is. It's an agreement between you as the individual yourself and you as the trustee of this trust, in a sense the boss of this trust. And in creating that shell and moving assets out of your name and into the name of the trust, you no longer own the assets individually. You personally don't own the assets anymore. Now the trust owns the assets. Okay? You keep control. Kind of like software. Software's all licensed out. You buy Microsoft Office. You're not buying Microsoft Office. You're buying permission to use it. Same with the trust. When you move those assets into the trust, you now, as the trustee, keep control over everything. You can put stuff into and out of that refrigerator all you want. You got a home that's titled to the trust. Sell the home, you take it out of the trust, and so on. Whatever's in your name when you pass away has to go through probate. There's some small exceptions. But whatever's in your name when you pass away, but ownership-wise, has to go through probate. If it's in the trust, not in your name. Okay? It's a workaround, it's a complete workaround. It's almost like a trick, but it's the way the law reads it. So the law of contracts apply to trusts. Private agreement between the trustee and the trustor, the settlor, the creator, the grantor is the term we use for the person that creates it. And even there's some debate on this, whether the beneficiaries, whoever the recipients are, and whoever the assets are, get to see the entire trust. Okay? That's not even clear. So they may get to see the page where it says what they're entitled to, but they may not get to see the entire trust. So again, a lot of this comes down to money, okay? Because if you do end up in probate, you're looking at, on average, 5 to 8% of your gross estate going to the unannounced heir, me, the lawyer, okay? Or between me and the court system. So if you have, it's, living in the north suburbs, it's not hard to get to $1 million in assets, even though we all don't feel that rich, between a house and other assets. $1 million passed on to your kids, you're looking at $50,000 to $80,000 potentially in probate fees before your kids get anything. Versus doing a trust, funding it properly, which the cost varies, but you're looking at $3,000, $4,000, or $5,000 depending on what exactly you need. And that says nothing about the headache of probate, of that 2 to 3 year window that you're forced dealing with, or your kids, I should say, your kids are forced dealing with, and frankly can't even mourn. There's obviously the religious and personal, emotional, spiritual aspect of all of this. And so when, any planner that's done this for years and years, and it's like any plan. It's a lot of what I talk about when I sit down with a client, it's more logic than legal. It's, hey, you know your kids, you know which one's better with money, you know which one is better with this, which one's better with that. Think about those things when you decide who you want to be your trustee. Think about those things when you decide who you want to manage the assets, if there's something to hold on to longer term. Think about if you have a lot of people now, they don't like the idea of outright distributions. They want to stagger it. My child at age 25 will get up 1/3. At age 33, they'll get 1/3. At age 40, they'll get the rest. Great. If you want to stagger it that way because you feel maybe they're not responsible enough with money, or a lot of times it's not your own kid, it's the spouse. And the daughter or son-in-law creates a rift. There's something there that if you stop and breathe into it, think about it, you can forecast the problem down the road. And in doing the trust, in doing that work, and putting that thought into it, you're saving everybody a ton of headaches. And that's, again, apart from the money side. So you've got, the will versus trust. Everybody needs something. And the way we're all born with religious needs, born into this world as sinners, and baptism and such, you're born with legal needs. It's just the way it is. You're born with, you need a will, you need a trust, you need something in place. And that's not even to get into the medical document side, which I'll get into in a moment. But whichever way you go, take some action, do something. Whether you just do a will, and when people think about what to do, it's the cost comparison most of the time. They don't understand the impact of a will versus a trust, and they're looking and they're saying, "Oh, I can do a will on LegalZoom for $250." Great, lawyers love LegalZoom. We love cleaning up the mess that LegalZoom has created because it's just not tailored to you. It's a form stock document. It's a document generation company. That's all they do is generate documents, and it works out perfectly for the us's of the world because we're in court trying to resolve all the problems that LegalZoom created, and billing endlessly for that. Yes.
I have a question about the trustee.
Yes.
When you have a trustee, is it better to have somebody outside of your family as trustee or somebody in your family?
So, great question. So her question was, is it better with a trustee to have someone inside the family or outside the family to act as trustee. So moving into the anatomy of the trust, and I'll address that question as I talk here. You've got multiple components, things that have to be in the trust because the law says it has to be in the trust. You've got the creators of the trust, they're named, okay, so it's me and my wife, Rudy and Kate Minasian, creators of this trust. Then throughout the trust, I am naming people that I'm going to be the husband and wife, if it's the typical family structure, husband and wife are going to be trustees together of their trust, initially. On the death of the first spouse, the surviving spouse will remain the sole trustee. Again, typically. When that second spouse dies, that's where the issues come. That's where the question of who is the successor? Okay. There's really no good answer. It's no good answer to your question. It's not a fun job to be a trustee. I've done it, and I'll do it again. But you're not doing your children any favors by making them trustee. Unfortunately, as children, I think it's just an obligation in this banking world that we probably, many of us will have to take on that role of executor or trustee, or just dealing with affairs. I would say the options are, if you have children, typically children, if no children, nieces and nephews, or maybe siblings, you most likely want someone younger than you just because of actuarial statistics and the likelihood of them passing away after you, so that somebody's actually there in place. The other option, as far as non-family goes, friends are fine. I mean, if it's somebody that you trust with your kids, with your money, no problem. If you take that up a notch, then you're looking at what we call a corporate trustee, which would be a bank. Okay? Certain banks are in the business of being trustee. Northern Bank and Trust, for example. Actually, I don't think they have a trust division anymore. They sold it off. But for a while, that was a good portion of their income. They act as trustee. The burden of selecting a non-relative or not an individual as trustee is, with the bank as trustee, every time you blow your nose, you have to call them to ask permission. So, and they bill like crazy. They typically take 1.25% every year of whatever they're holding on to. So they do make a lot of money off that. On the flip side, you are taking that burden away from your kids or whomever it is you would have otherwise made trustee, and you know the rules are going to be followed because the bank trustees, the financial trustees, are very strict about how to do that. There are actually some law firms that all they do is trustee. They're professional trustees. So you have options there. I would say for the most part, if your kids get along, yeah, that's key. If your kids get along, if you have multiple kids, they get along. If it's not an overly complicated scenario, there's no problem naming your kids as trustee. Okay. Most likely, as soon as mom and dad pass away, they're going and running to an attorney anyway to figure out what to do. If it's not an attorney, it's an accountant, and the accountant's going to say, yeah, I can handle the last tax returns, but you're going to have to get an attorney to deal with all the legal, the trust administration stuff. So does that answer your question? Somewhat. So, kind of going back to the anatomy of the trust, you've got the creators of the trust, you've got the trustees, which are typically also the creators. When the creators pass away, then you end up with whoever the successor is. The successor's job is to do what the trust does. 98% of trusts probably say, upon my death, my assets go to my kids in equal parts, and the trust is to be closed with them. Okay. That's usually what people want. That's obviously the cleanest setup. There's specific examples here where there's a longer term. Again, I touched on the ownership scenario of a small business. Usually, unless you're Andy Warhol or you have some sort of income stream coming in, like you own a baseball team, you own something, in that situation, the trust would have to stay open, okay, until such time the asset is sold. Okay? Otherwise, the trust is that shell holding the asset, and mom and dad pass away and the kid's in charge, and I'm not able to go sell these business shares that are owned in conjunction with others. The trust stays open, just the car door has to stay open. All the kids are in the car. Only then can you close it and drive away. It's the same situation. But again, for the typical scenario, we're looking at, you have a trust, you have distributions to your children or to whomever, somebody's in charge after you pass away, and that's it. And their job is to do the trust administration, pay funeral expenses, pay any other expenses, make sure final tax returns are filed. If an estate return is necessary, that gets filed, and then it's done. It's wrapped up. And the beauty of that process, as convoluted as it can get sometimes, is there's no court involvement. There's no judge that oversees everything. There's nobody telling you what to do, other than presumably a lawyer that's helping you through the administration process. And that's it. It's a simple process. A real world example: you have a will or you have nothing. Okay, say you have a couple kids, you do a will. So you get that far, you do a will. You pass away. Now the kids want to sell the home, okay, that you live in. And the home is, value doesn't matter, let's put a number just for sake of simplicity, $300,000. Your kids contact an attorney, realtor, they list the home, they want to sell the home, the realtor gets a contract, goes to a title company says, okay, we see that the person on title, the owner on title, is deceased. We're very sorry for your loss, but we can't do anything. We cannot allow you to sell this property. It's stuck here until we have court documentation showing that you have authority to sign. Because the only party that had authority to sign is now deceased. Okay? And so title company can't insure, documents can't be signed, conveyed over. In that situation, the heirs are forced to go to probate. They're forced to open a court proceeding to get a judge to sign an order and do all this other stuff that allows someone to sign on behalf of the deceased. Okay, so you're talking about, the process of getting probate open is probably 2 months on average. Getting probate closed, that's where you get to that 2-3 year mark. Once it's open, then the executive has the authority to do what they need to do to sell the home. But the hurdles you have to go through and the can of worms that you open to get to that point, that's the problem. On the flip side, there's a trust, same scenario. Mom and dad pass away, the kids now have to deal with the house, they want to sell the house is in trust. They sign a contract, they go to the title company says, thank you very much, we're sorry for your loss, can you send us your identification, can you send us the death certificate, and can you send us a copy of the trust? Or at least the portion that says that you're the trustee, and the signature pages show that it was properly executed. That's it. You took a process that was potentially 3 years before it was said and done, and tens of thousands of dollars, down to 20 minutes, give or take. Same with the bank. I walk into the bank, I pass away, my kids go to the bank and say, we're here, we're his kids, and here's his death certificate, here's our ID, we get all the money. The bank says, again, sorry for your loss, but we can't do anything until we have a court order saying you get access to those funds. You're the executive, you're the administrator. On the flip side, if that bank account is in trust, same situation, bank says, okay, give us the death certificate, give us your ID, tell us what you want done with the funds. That's it. So, again, if everything worked on a handshake, we wouldn't need any of this. But when you get to these financial institutions, these title companies, they know the laws, and the laws say that the person that owns the home is the person that has to sign the deed. The person that is on that bank account is the only person that can withdraw the money. And so that's where you run into the problem, and that's where having a trust is so critical, because again, the bank doesn't care who is the owner of that account. They care about who has access to it. And so if the account is held in trust, the bank will change the account to be held in trust. They just need to know, what does the trust say? And who can I deal with? Can I deal with Eve Minasian, my daughter? Can I deal with Rex Minasian, my son? If that's the case, and that person can prove up who they are and give a death certificate showing that I'm deceased, the bank will do what they're told because it's in trust. So that's yes.
Most of us have been told about the rights of survivorship when we buy houses or open bank accounts. It sounds like in case the plane goes down or the car accident, you both die, then it goes into probate if it's not in a trust. Is that correct?
Correct. Yeah. Yeah, so her question was, in that emergency scenario where the plane goes down, or there's a car crash, or some catastrophic event that leads to an unexpected death, then what? Assuming there's no plan in place, somebody would have to go petition the court. They'd have to go petition the court to put probate in. Okay? Who that somebody is, if your kids are minors, it can't be them. So perhaps it's a sibling, perhaps it's a parent. And at that point, there's no will, there's nothing to work off of. The judge, the court system is working in the blind. So they will open a probate estate after all the documents are filed, but then you have this mess of figuring out what's where were my parents' assets, what were my parents' assets, who do I have to call, where do I even begin? And again, that all those questions are time consuming, they disrupt the grieving process, they are expensive to answer, because most likely you're calling a lawyer or a law firm that's going to kind of sort through all your issues one by one. Does that answer your question? Yeah. So that's, if nothing is in place, everything most likely ends up in probate, unless there is a workaround, but you have to have minimal assets for that workaround. Illinois has a law that says that probate is not needed if you have under $100,000 in assets. You can use a small estate affidavit in place of. And this is becoming increasingly a problem. Banks care about the laws when it benefits them. They don't care so much about the laws when it does not serve them. And so I've heard plenty of scenarios where a bank will not accept a power of attorney, or a bank will not accept a small estate affidavit, or whatever the case is. So again, in that situation, you're far better off having a plan in place and having it done right than run the risk of that catastrophe scenario where then all of a sudden your kids or your siblings go running to the bank or whoever title company to sell the house, and they run into roadblocks because they will. Okay? Hospitals are the worst. They will legally. I can get a napkin and I can write on the napkin. The hospital is the whole club. If I'm on life-sustaining equipment or I'm feeding kids or whatever, and I execute it properly in accordance with the law, the hospital, the administration will look at me and laugh. They're just not going to honor it because it's not in the state prescribed form, even though it's completely legal. And my kids are not going to go sue the hospital. They're not going to go sue the bank when the bank says no. We're not going to accept that because it's not what we're used to. And they don't have lawyers sitting on the sideline waiting to review these documents to make sure they're legit. So unfortunately, kind of the way the world has gone, this process of standardized medicine, standardized legal, and the way that the medical system interprets legal, they want to see the Illinois statutory form. They want to see the Montana statutory form. You're in California and you did your plan in Illinois, your form's legit. In California, your trust is legitimate in California, but somebody in California, somebody at a California bank might not like it because they're not used to it. So they might reject it. They might force you into a position where you have to take legal action, or you just have to draft an entirely new trust in California, even though that shouldn't be the case. But I've seen it happen. Yes?
Is it more advantageous with capital gains to have a trust fund?
Yeah, good question, George. So George asked a tax question about capital gains. I can get into the tax stuff. Trust, so a couple of distinguishing features here. A trust does not have any asset protection to it. This is more about probate and the cost of probate, okay, and avoiding the headache of probate. George's question about capital gains. So what capital gains are is if you have an asset that you hold over a certain amount of time, it falls into a different tax classification. Instead of you paying taxes on it at the ordinary income tax rate, which is on the IRS website, all over the internet, it starts at percentages now, but I think it goes up to like 36.8%. If you have an asset that you hold on to for a certain amount of time, that asset, if you sell it, will get taxed at a lower rate, totally different schedule. Okay? Makes no difference whether the property is held in trust or held individually as to whether capital gains applies. Trusts do not affect tax rates necessarily in that situation. In the post-death scenario, That's different, because trusts are taxed, irrevocable trusts are taxed at their own tax rate. So when you create a trust, something I'll talk about a trust. The trust itself doesn't have its own tax identification number unless you get one. It's stuck with your tax ID. Any income, if you own an investment property, you've got rental units and you've got people paying rent, it doesn't matter whether they write those rent checks out to the trust or to you individually. That income is going to be tagged to you individually. It's going to go on your regular 1040, okay? And you're going to pay income tax on it just as you otherwise would with a wage payment or a 1099 payment or whatever. When the trustors pass away, at that point, no more income tax can be attributed to the trustors. Okay, so when I die, my social security number cannot take on any further income. If I have a trust, that trust then needs its own tax ID. And when the trust gets its own tax ID, presumably it becomes irrevocable at that point. Then the trust tax schedule applies, and that tax schedule is through the roof. It goes up to 45%, and this, and a lot of this is, forgive me, whatever political side you're on, but this current political administration, they were talking about, at the time when the elections happened, looking at potentially 77% on the tax rates, on the estate trust tax rates. Okay, so right now I think the max is 45. Of course, government's always looking for revenue, and that was one solution in their mind to get more revenue. On the tax side, which is a good topic, and I'm going to bring up kind of some of the history of this. There is an estate tax. If you pass away with too much money, which is some arbitrary number that the government decided, then they want their piece. Okay, and then in our minds, and it's been a Republican-Democrat battle for ages, Republicans have consistently said this is double taxation. You are making this money during your lifetime, you're paying tax on this money during your lifetime, you're passing it on to your children because you didn't spend it all during your lifetime, and through that bridge, you're getting hit with taxes. Again, why is that fair? There's been no good answer to that question. The proposal has been flat tax, but the response is, well, number one, Democrats say, well, we need money for, the money that comes in on estate taxes is specifically allocated towards underprivileged programs and so forth and so on. But more important, the whole entirety of the estate tax is to prevent what happened in England. Okay? We don't want the scenario where 1, 10, 100 families are passing wealth down from generation to generation, creating a monarchy scenario. Okay? Which is exactly what we have in England. And so that's the reason for the estate tax, is to prevent this almost absurdity of multiple families being able to just keep passing wealth down and, in a sense, taking over the country. My take on it is it's a great premise. One thing that the founders, the estate tax implementers, failed to acknowledge was this is happening now, but kind of through corporations. It's the Microsofts of the world, and the Oracles, and the Amazons, and so forth, to where the owners of these companies, who are multi-billionaires through stock, you can kind of keep passing, even though they've all signed a pledge, I know, to donate 95% of their money when they pass away. They can keep passing money on from generation to generation. They can put it into tax-free municipal bonds, and to where it just keeps accruing income and there's no tax. And this can happen, they call it a dynasty trust. You can set up a trust that holds assets that have no income tax attributable to them, and you can pass the money on from generation to generation. So that's the split on the estate tax is, one, it's double taxation, so it shouldn't exist. On the flip side, it's, yeah, well, if it doesn't exist, we've got this scenario where only a few families are going to run the country, basically, because they're going to have amassed all the financial wealth. The estate tax itself has a little interesting history. When industrial revolution obviously was 1800s, but war end, farmers, population boom. You've got the Reagan era when the estate tax threshold was $636,000. So the government at that time in the 80s said, if you have more than $636,000, you pass away. we're going to take our piece. We're going to tax at least half of it. Okay? Starting at $636,001, we're going to take our piece. So 80s come, all the farmers start dying off. Okay? IRS comes in and values their real estate. Maybe they have 300 acres of corn land or whatever. And IRS says that land is worth $3 million. You have a lot of acreage there in a desirable area. The farmer's family, farmer's deceased, the family says, okay, great, except we don't have a dime to our name. We're just getting by doing our farming and exporting our goods and such. And the government says, okay, well, too bad. It's still $3 million in land. Take away $636,000. That leaves you with a state tax liability at about $2.4 million, and we're going to collect 50% of that in tax. So you owe us $1.2 million in 9 months. Okay? That's the estate tax. So that's where the phrase came from, sell the farm. All these people were forced to literally sell the farms at a discount so they could pay off the IRS. Because they didn't have any assets. All they really had was the hard land that wasn't worth what the IRS said it was worth, but I guess in practical valuation, it wasn't, but for tax purposes, they value it higher. From there, Congress started picking up on what's going on. They increased that threshold, went from 636 up to $1 million, went from $1 million to $2 million, and then bounced up year after year until one year when there was no state tax exemption, but there was a catch to that. And then it came back to, I don't know, 5 something. Right now it's at $12 million. So for federal government purposes, if you pass away with $12 million or less in your name, you're not going to owe a dime in state tax. Okay? Good. The Forbes classifies rich as having $25 million or more. So even, you're not even rich at that point. But whatever, $12 million, you get past that tax rate. If you have a spouse and you have a proper plan, their $12 million can be combined, and then you've got $24 million that can be passed on tax free. But you have to have a plan. You have to have a plan in place for it to work that way. So that's kind of the history of the taxes and going forward. So when I talk about estate planning, rarely do I talk about the tax side of it because I've only had a few clients over the years that will run into a problem with taxes upon death. Okay, and we're not all sitting around with $25 million. If you are, please call me as soon as I have the speech. But when you deal with estate planning, you're more concerned with privacy and not letting the whole world see what your assets are when you pass away, because if you have to go into court, it's all public record. You're dealing with probate avoidance and cost issues. You're not so much dealing with tax as you would have been if you were planning in the 80s. The tax threshold was much lower, it would have been a problem. That said, every state, not every state, but I think there's 12 or 15, have their own tax thresholds. Federal government's not enough, each state has to dip into your pot and get their piece. So Illinois is at $4 million. If you pass away with $4 million or more, they go back to $1, and they tax from $1 all the way to what you have. And they've got a graduated schedule, I don't know what the rates are. But yes, ma'am.
So if all your assets are in retirement accounts and in bank accounts and in the beneficiary, you still do have.
So good question. And this is, perhaps I can just open up the questions after this, but maybe the last thing I touch on. If all your assets are in retirement accounts or bank accounts or potentially life insurance, or they are in something that has its own beneficiary designation, okay? That goes outside of probate, and that goes outside of the trust. That's another kind of a workaround. So in that sense, you don't need a trust, or you don't need an estate plan if your only accounts have beneficiary designations on them. Okay, does that answer your question?
Yeah.
Now, that said, a lot of people, especially in my experience, especially ethnic, they want to add their child to their home. Okay, because they think that's the best way, that's the easiest way to just pass the property on to the kid. Or they want to put their child on their bank account. Now, I've run into the situation probably 4 times where parents, I had one that's clear as day, parents had a home in Sarasota, they lived in Chicago suburb, had a home in Sarasota, their winter condo was worth a couple $1 million. They had a bank account they got and banks are all national now, but it was a Chase bank account, and they had about $100,000 in there, which would cover the annual maintenance and taxes for this unit. They put their daughter on the account just to make sure if anything ever happened to them, somebody would have access to that money. Daughter also lived in Chicago suburbs, building a house, market tanks, 2008. She goes underwater, ends up filing bankruptcy. Okay? Doesn't tell her parents. Parents have no idea. 4 months later, the parents get a call from the property manager of their Sarasota condo and say, hey, your assessments haven't been paid. What's going on? Assessments were like $3,000 a month. What do you mean? Nothing changed. What's going on? Well, check into it because we haven't received your assessment money. Well, it turns out when the bankruptcy was filed, the assets were frozen. The daughter was on that bank account, so they get to freeze that bank account too, even though it was quote unquote the parents' money. And that was it. That money was gone. That money went right toward paying off the creditors of the bankruptcy. And the same scenario with the house. If you add your kids to a house, if your child, and when I say child, I'm talking about a minor, that's different. 20, 30, 60 something year old child. If they get into a car accident, or they have credit card debt, or they have any kind of creditor claim against them, and they end up with a judgment against them, and they can't satisfy that judgment, they can't pay whoever that creditor is out of their own pocket, the creditor can seize the home. The creditor can force a sale of the home to get their money that way. So in a sense, you're in your 80s and you've got a 50-year-old kid who was never good with money, he or she is on their third bankruptcy, and you put them on your house because you think, the time is near, you just want to put them on the house and you make sure they get the house. And they get into a car accident or they have some kind of claim against them and that insurance doesn't cover, you could end up losing your house within a year or two at most of something like that happening. So that's the danger of, that's I would call that a shortcut, really. It's not really planning. It's a fix. It's a band-aid. It's saying, I'm just going to put my kids on my home, and that way when I pass, I don't have to deal with a will or a trust or anything. I can just set it up that way. And when I talk about putting kids on a home or even putting assets into trust for a home, it would be, we all know, you own a home through a deed. A car is a title, a home is a deed. A deed is what conveys real estate from one party to another. To put assets in a trust, to put a bank account or a house in a trust, we would do a new deed. Okay, that part of the process is not happening. You would quit claim. It would be a quote quit claim. You would quit claim your interest in the home to your interest as the trustee of the trust. For a bank account, you walk into the bank with a copy of the trust and say, here you go. I want to now retitle my bank accounts into my trust. So and I'll try to kind of wrap it up here. The three-part process of planning, one is the information gathering. That's me or some other attorney reaching out and saying, here's my questionnaire, come in if you want me to help you. I'll fill it out with you. We can talk about your scenario, we can figure it out. 2 would be the lawyer's piece, that would be the planning part. That's where I'm looking at the questionnaire, filling in who you want to be your beneficiary, who you want to be your trustee, any specific circumstances, personal property stuff, which I'll get to in a sec, and then of that planning part, that's where we would do the execution. The third piece is the funding. That's the putting stuff into the refrigerator. That I can't do for you. That's the part. This is the part where things kind of fall off the cliff the most. Is I can help you get prepared. I can do the information gathering with you. I can execute the plan with you. But I can't go to the bank for you and say, hey, this is my client's trust. They want to move their bank account into the trust. They'll back me out of it. Okay? I'm not the account holder. I can't do it. Even if you email them and said, hey, my attorney has permission, it's not going to fly. They're going to allow me to come into the bank with you if you even want me there and do it that way. So that's the funding part. So you've got this 3-part process of information gathering, the actual planning, and then the funding part. On personal property, this is a touchy subject for a lot of people. We're very attached to our things. It's the way life is. Especially us, we've got a lot of heirlooms and things that potentially have survived. I know people with deeds I know of land and going back to what is now Turkey. Even copies of those documents. Who gets all of that stuff and how to distribute it? Another question to which there is no good answer to, requires a lot of thought. If the kids don't care, that makes things a lot easier. If the kids do care, different story. I've had scenarios where somebody has come in and said, I don't know what to do. They were very attached to all their personal property. I've got 2 daughters, and somebody needs to pick first. So I said, what about a coin toss? And he loved the idea. Okay, so we literally, in his trust, we draft that there's a coin toss by a neutral party, and the winner of the coin toss is the daughter that first gets to choose an item from the house and keep it. And when she's done, then the other daughter gets an item. And it was this alternate, every other, back and forth. He had no better way to do it, and again, this is not an issue of judgment or ego, it's whatever you want to do, whatever you want to do. Know what you're putting your kids through when you do it, but again, it's up to you, whatever you want to do. So, there's some things that are obvious. If you have a daughter and a son, perhaps you want the jewelry to go to the daughter. That would logically, I guess, make sense. If you have a baseball card collection or memorabilia, sports memorabilia, perhaps you want that to go to the son or to the nephew, as opposed to the nieces. Again, it's up to you. You can't worry about what anybody gets offended at. They're going to be dead and gone, possibly laughing from the grave, having the shish kebab party at Irving Park every Friday. But again, there's no good answer to that question. The one thing that if you do have valuables, if you have gold coins, if you have oriental rugs, if you have something that you want to make specific mention of, tell the attorney. There's a lot of times where, this is one big reason I bring people in my office, they forget what they have. And it's not because of memory loss. They just, oh yes, I forgot I have this. Or they come to me when there was an estate plan done and there's a lot of stuff that wasn't in. Yes?
I have one question, which I know everybody's dying to hear, which is, if I want to make a donation to the church, do I put that in the will or the trust or both, or on a piece of a napkin and stick it under my bed? How do I do that?
So good question, great question. And probably should have been the first question that I answered. But if you want to make a donation to the church upon death, you can put it in both, actually, if you do a will and a trust. The typical structure is for an estate plan. When I do that, and every attorney is a little bit different, but there's a binder, there's a thick customized binder that has a trust. It has a will as backup. I'll explain that in a second. It has medical documents, which are power of attorney for healthcare, HIPAA authorization, living will. There's 4 or 5 other documents that are part of this whole package. If you want to leave a bequest, you're going to do it either in the will or in the trust or in both. If you do a trust, we would put into the body of the trust, I want to donate X to St. Gregory Armenian Church. And perhaps you want to specify more. Perhaps you want to go to the Niagara Choir. Perhaps you want to go to something specific program. Illinois is great about that because there is, again, no government oversight. New York, which I'm licensed in New York and Texas, it's a train wreck. If you're a New York resident and you're leaving something to charity in your estate plan, the Attorney General's office gets involved. And the trust has to go to the Attorney General's office because they are kind of the enforcers. They're the trust police, and they're making sure that whatever assets were left to the church or whatever church or the Community Humane Society, they make sure that those assets take there. But Illinois doesn't have that rule, so in the various scenarios where I've dealt with that charitable organizations, it's the trustee's job, and usually I end up doing kind of the labor of it. I'm marshaling the assets upon death, gathering all the assets, selling the home, putting the money into a bank account, closing out regular bank accounts and putting them into this one trust account, trying to gather everything into one place, and when I have all that done, and all the expenses are paid out, then I'm looking at this gross number, and if it says 5% goes to St. Gregory, I'm sending St. Gregory a copy of the document, trust document, and a check for the 5%. Okay, pretty simple, pretty clean. That said, the overall trust administration process itself is not that simple, but when it comes down to it, when everything's gathered and all the labor is done, it's a matter of, just envision this in your mind, the simplicity of it, of the trustee looking at a bank statement, seeing that total number and saying, okay, 5% goes to St. Gregory, 10% goes to my child, 20% goes here. And it's just that breakdown, okay? Anything else? Any other questions? I didn't get into the medical stuff. There are 3 core medical documents, which is important to know, especially now, because so many people we're all living longer because of the blessing of the pharmaceuticals, but it's creating more problems, in the end, physically for people, so they're having a harder time getting around. medical documents are as important to have as anything else. Power of attorney lets someone make medical decisions when you're unable to. Okay. It is what the hospital will ask for. They'll also ask for what they call a DNR. A DNR is a medical document. A living will or an advance directive is the legal version of that medical document. Both kind of say the same. The hospital, Illinois, I think, has its form DNR. But the legal DNR basically says, if I'm in a car accident or some horrific event, and I am mentally incapacitated, physically incapacitated, if it takes breathing tubes and all of this stuff to keep me alive, life-sustaining equipment, then it's my desire to be removed from that equipment. That's what a living will is. You don't change a living will, you either sign it or you don't. Okay? If you want to be on life-sustaining equipment, if you are a bionic man or bionic woman, or you think you can be freeze-dried and brought back to life in 2076, don't sign the living will. Okay? But if not, sign the living will, and it basically is directive to the hospital as to what your wishes are if something were to happen. Everybody here is old enough to remember, there was a case in Florida, Terry Schiavo was her name. It was probably 25 years ago, and there was a battle. She was in a vegetative state. She was in a hospital in Florida. Her husband and her parents wanted two different things. Parents wanted to keep her alive. Husband wanted to pull the plug. It was national news. I don't think I was even in law school yet. I don't remember it well. It made it to the governor. Jeb Bush was the governor at the time, and to the Florida Supreme Court. Eventually, the husband won, and they pulled the plug. I don't remember a lot of particulars in there, but that was a scenario where if she'd done an advance directive, none of it was newsworthy. She would have been one more patient in a long line of patients that suffer from debilitating diseases and made their wishes known prior to the you-know-what hitting the fan, excuse my language. So, again, all this is back to plan. You're making a plan. If you can, and I make plenty of to-do lists in my life. Estate planning was never on one, at least not in the top 10 of my own to-do list. So I know it's something that's not all that fun. I realize, probably more so than most attorneys, that this is a service business, and I'm very compassionate to that. I never pressure anybody into doing something. It's, I welcome you with open arms. When I want to sit down, talk about it, not even do anything, I'm happy to listen and talk and discuss and kind of walk through scenarios. If you want to do something, I'm here for you. Everybody can, if you don't have my number, you can track it down. Feel free to call, ask me questions anytime. Is there anything else anybody wants to raise? Any other questions? No? Thank you so much for listening. I appreciate it.
Thank you, Rudy. As he said, if you have any questions, further thoughts, opinions, we're more than happy to provide the contact information for Rudy. He's no stranger to St. Gregory. And so thank you again, Rudy. Thank you everyone for staying and asking such engaging questions. Safe travels, drive safe, stay well, have a great week. God bless.